Small world, the world of informative flashcards. Flashcards in Total FAQ on Mediation Part 1. In the Philippines, what is the law on mediation? The law is Republic Act No. 9285, otherwise known as an act to institutionalize the use of an alternative dispute resolution system in the Philippines and to establish the Office for Alternative Dispute Resolution, and for other purposes. It was enacted on April 2, 2004. Mediation, Introduction. Introduction. Mediation, also known as conciliation in many parts of the world, has a long history in the diplomatic arena. In the commercial world, interest in it has increased sharply in recent years. In part, this growth of interest is attributable to dissatisfaction with the cost, delays, and length of litigation in certain jurisdictions. The growth of interest results also, however, from the advantages of mediation, particularly its appeal as a procedure that offers parties full control over both the process to which their dispute will be submitted and the outcome of the process. Where mediation has been used, it has enjoyed very high rates of success in achieving a result acceptable to both sides to a dispute. Because it is a relatively unstructured procedure, however, some hesitate to use it for fear of not knowing what to expect. This document seeks to allay such fears by explaining simply the main features and advantages of mediation and how mediation under the WIPO mediation rules works in practice. What does mediation explain? Mediation is a process wherein the parties meet with a mutually selected impartial and neutral person who assists them in the negotiation of their differences. What is the main purpose of mediation? Even if disputants do not resolve the dispute, mediation frequently will bring out the real issues and enhance communications between the parties, fostering an improved working relationship. What are the 7 types of mediation? Facilitative mediation, court-mandated mediation, evaluative mediation, transformative mediation, MED-ARB, ARB-MED, e-mediation, multi-party mediation, co-mediation, shuttle mediation. What is facilitative mediation? In facilitative mediation or traditional mediation, a professional mediator attempts to facilitate negotiation between the parties in conflict. Rather than making recommendations or imposing a decision, the mediator encourages disputants to reach their own voluntary solution by exploring each other's deeper interests. In facilitative mediation, mediators tend to keep their own views regarding the conflict hidden. What is court-mandated mediation? Court-mandated mediation. Although mediation is typically defined as a completely voluntary process, it can be mandated by a court that is interested in promoting a speedy and cost-efficient settlement. When parties and their attorneys are reluctant to engage in mediation, their odds of settling through court-mandated mediation are low, as they may just be going through the motions. But when parties on both sides see the benefits of engaging in the process, settlement rates are much higher. What is evaluative mediation? Evaluative mediation. Standing in direct contrast to facilitative mediation is evaluative mediation, a type of mediation in which mediators are more likely to make recommendations and suggestions and to express opinions. Instead of focusing primarily on the underlying interests of the parties involved, evaluative mediators may be more likely to help parties assess the legal merits of their arguments and make fairness determinations. Evaluative mediation is most often used in court-mandated mediation, and evaluative mediators are often attorneys who have legal expertise in the area of the dispute. What is transformative mediation? In transformative mediation, mediators focus on empowering disputants to resolve their conflict and encouraging them to recognize each other's needs and interests. First described by Robert A. Baruch Bush and Joseph P. Folger in their 1994 book, The Promise of Mediation, transformative mediation is rooted in the tradition of facilitative mediation. At its most ambitious, the process aims to transform the parties and their relationship through the process of acquiring the skills they need to make constructive change. What is MEDARB? MEDARB. In MEDARB, a mediation arbitration hybrid, parties first reach agreement on the terms of the process itself. Unlike in most mediations, they typically agree in writing that the outcome of the process will be binding. Next, they attempt to negotiate a resolution to their dispute with the help of a mediator. If the mediation ends in an impasse, or if issues remain unresolved, the process isn't over. At this point, parties can move on to arbitration. The mediator can assume the role of arbitrator, if he or she is qualified to do so, and render a binding decision quickly based on her judgments, either on the case as a whole or on the unresolved issues. Alternatively, an arbitrator can take over the case after consulting with the mediator. What is ARB-Med? ARB-Med. In ARB-Med, another among the types of mediation, a trained, neutral third party hears disputants' evidence and testimony in an arbitration, writes an award but keeps it from the parties, attempts to mediate the parties' dispute, and unseals and issues her previously determined binding award if the parties fail to reach agreement, writes Richard Fullerton in an article in the Dispute Resolution Journal. The process removes the concern in MEDARB about the misuse of confidential information, but keeps the pressure on parties to reach an agreement, notes Fullerton. Notably, however, the arbitrator/mediator cannot change her previous award based on new insights gained during the mediation. What is e-mediation? E-mediation. In e-mediation, a mediator provides mediation services to parties who are located at a distance from one another, or whose conflict is so strong they can't stand to be in the same room. E-mediation can be a completely automated online dispute resolution system with no interaction from a third party at all. But e-mediation is more likely to resemble traditional facilitative mediation, delivered at a distance, write the chapter's authors. Thanks to video conferencing services such as Skype and Google Hangouts, parties can now easily and cheaply communicate with one another in real time, while also benefiting from visual and vocal cues. Early research results suggest that technology-enhanced mediation can be just as effective as traditional mediation techniques. Moreover, parties often find it to be a low-stress process that fosters trust and positive emotions. What is multi-party mediation? Multi-party mediation. This is simply mediation conducted to resolve a dispute between two or more parties. Because multi-party mediation can be extremely complex, co-mediation is often employed. An initial meeting with the parties will allow the co-mediators to develop a plan for mediation going forward. They may also ask one or more parties to prepare for mediation by completing certain tasks. This gets the parties to start thinking about negotiations and potential solutions well ahead of time. During the mediation session, the co-mediators will facilitate individual conversations. They will also meet to exchange information and share progress reports. If all goes according to plan, the parties will be able to reach consensus on a solution which can then be formalized in a written agreement. What is shuttle mediation? Shuttle mediation is a technique in which one mediator works with both disputants. But instead of engaging everyone as a group, the parties are separated. In some cases, they will remain in the same building, but stay in separate rooms. Sometimes the disputants will have meetings with the mediator on different days, or at different times. The mediator speaks with each party separately to convey proposals, terms, or concerns. As in other types of mediation, the mediator cannot decide or influence the outcome. What is co-mediation? Co-mediation. Co-mediation is a process in which two mediators try to help the parties resolve their differences. One mediator works with each party, thereby eliminating any concerns about fairness or objectivity sometimes associated with traditional mediation. Other than that, the process is no different than traditional mediation. Each mediator helps the parties try to reach consensus by creating an environment where they can pinpoint the source of the grievances, develop potential solutions, consider other options. As in traditional mediation, co-mediators cannot give the parties advice about the merits of the dispute or make any decisions about the result. However, they can offer advice about the mediation process. They can also decide which mediation techniques to use to promote resolution. What are the stages of mediation? Stage 1: Mediator's opening statement. After the disputants are seated at a table, the mediator introduces everyone, explains the goals and rules of the mediation, and encourages each side to work cooperatively toward a settlement. Stage 2: Disputants' opening statements. Each party is invited to describe the dispute and its consequences, financial and otherwise. The mediator might entertain general ideas about resolution, as well. While one person is speaking, the other is not allowed to interrupt. Stage 3: Joint discussion. The mediator might encourage the parties to respond directly to the opening statements, depending on the participants' receptivity, in an attempt to further define the issues. Stage 4: Private caucuses. The private caucus is a chance for each party to meet privately with the mediator. Each side will be placed in a separate room. The mediator will go between the two rooms to discuss the strengths and weaknesses of each position and to exchange offers. The mediator continues the exchange as needed during the time allowed. These private meetings comprise the guts of mediation. Stage 5: Joint negotiation. After caucuses, the mediator might bring the parties back together to negotiate directly, but this is unusual. The mediator usually doesn't bring the parties back together until a settlement is reached or the time allotted for the mediation ends. Stage 6: Closure. If the parties reach an agreement, the mediator will likely put its main provisions in writing and ask each side to sign the written summary of the agreement. If the parties didn't reach an agreement, the mediator will help the parties determine whether it would be fruitful to meet again later or continue negotiations by phone. What are the 7 elements of mediation? The 7 elements include interests, legitimacy, relationships, alternatives, options, commitments, and communication. A 7 elements approach can be particularly helpful during pre-negotiation preparation. What are the 6 techniques for mediation? 1. Introductory remarks. 2. Statement of the problem by the parties. 3. Information gathering time. 4. Identification of the problems. 5. Bargaining and generating options. And 6. Reaching an agreement. What are the principles of mediation? The following principles were developed over a period of time by organizations involved in mediation and have been agreed to by both Mediation UK and the UK College of Family Mediators. The principles of mediation: impartial, skilled negotiator; voluntary, on the part of the clients; confidential; informal and flexible; decisions based on consensus; focused on the future to achieve a gain-gain or win-win situation or result and resolve conflict. What are roles of the mediator? Mediators help people to identify their own needs, clarify issues, explore situations, and negotiate their own agreement. Mediators do not advise those in dispute. Mediators are not counselors, but help people to communicate with each other. Mediators are impartial and must have no stake in the outcome of the process. The mediator will remain non-judgmental. The mediator will listen actively. The mediator will act impartially. The mediator will encourage changes in perspective. The mediator will seek out underlying needs and interests. What are elements of successful mediation? Those in dispute are willingly take part, are prepared to be open and honest about the situation and their part in it, want to work cooperatively with the other party to find a solution, want to continue to have a civilized relationship, feel that they are in a safe atmosphere. What are the instances when mediation may not work? If people feel coerced to take part. If one person is reluctantly attending. If another service, such as counseling support, is deemed more appropriate. If they have no need/wish to build a different future relationship. If people feel unsafe or threatened. If the mediator has a vested interest in the outcome of the mediation. What are some realities about mediation? Mediation is first and foremost a non-binding procedure. This means that, even though parties have agreed to submit a dispute to mediation, they are not obliged to continue with the mediation process after the first meeting. In this sense, the parties remain always in control of a mediation. The continuation of the process depends on their continuing acceptance of it. The non-binding nature of mediation means also that a decision cannot be imposed on the parties. In order for any settlement to be concluded, the parties must voluntarily agree to accept it. Unlike a judge or an arbitrator, therefore, the mediator is not a decision maker. The role of the mediator is rather to assist the parties in reaching their own decision on a settlement of the dispute. There are two main ways in which mediators assist parties in reaching their own decision, which correspond to two types or models of mediation practiced throughout the world. Under the first model, facilitative mediation, the mediator endeavors to facilitate communication between the parties and to help each side to understand the other's perspective, position, and interests in relation to the dispute. Under the second model, evaluative mediation, the mediator provides a non-binding assessment or evaluation of the dispute, which the parties are then free to accept or reject as the settlement of the dispute. It is up to the parties to decide which of these two models of mediation they wish to follow. The WIPO Arbitration and Mediation Center, the center, will assist them in identifying a mediator appropriate for the model that they wish to adopt. Mediation is a confidential procedure. Confidentiality serves to encourage frankness and openness in the process by assuring the parties that any admissions, proposals, or offers for settlement will not have any consequences beyond the mediation process. They cannot, as a general rule, be used in subsequent litigation or arbitration. The WIPO mediation rules contain detailed provisions directed also at preserving confidentiality in relation to the existence and outcome of the mediation. What are the advantages of mediation? In general, mediation has several advantages when compared to litigation. These are: affordability. Mediation tends to be a more cost-effective option. Efficiency. The mediation process can usually settle a dispute fairly quickly. Efficacy. Data shows that mediation is successful in more than 85% of initiated disputes. Flexibility. Mediation is less structured than litigation, and parties do not necessarily need legal representation. Empowerment. Disputants have the ability to create and reach consensus on solutions rather than having solutions imposed upon them. Confidentiality. Information provided during mediation may not be used as evidence in any trial or judicial proceeding. The only exception is if its use is required by law or the parties consent to its use. What is mediation in international law? Mediation in international law is a method for the peaceful settlement of international disputes involving the participation of a third party with the aim of helping the parties to the dispute agree to a solution.